What does at-will employment mean in your contract terms? Imagine starting a new job and wondering what your employment status really means. You might see the phrase at-will employment in your contract or company policies. But what does that actually imply for you and your employer? Let's break it down in simple terms. At-will employment is a common rule in the United States. It means that either the employer or the employee can end the employment relationship at any time. They can do this for any reason or no reason at all, without needing to give advance notice. This rule applies in most states unless there's a specific agreement saying otherwise. When you sign an employment contract, it might specify how long you'll work or what reasons are needed for termination. If it does, then your employment isn't at will. But if the contract is silent or states that your employment is at will, then the default rules apply. This means your job can be ended at any time without cause. Employees have the right to leave their jobs whenever they want. Employers can also dismiss employees without explaining why, but they cannot do so for illegal reasons. For example, firing someone because of their race, religion, gender, age, disability, or for reporting illegal activities is against the law. These are protected reasons that cannot be used as a basis for termination. There are some exceptions to at-will employment. If there's a written contract that states a specific job duration or outlines a process for firing, then the at-will rule doesn't apply. Sometimes, company handbooks or consistent practices create an implied contract, meaning the employee might have some job security even if the contract doesn't say so explicitly. Certain states recognize additional exceptions. For instance, firing someone for refusing to break the law or for reporting illegal conduct violates public policy. Some states also prevent employers from firing employees in bad faith or to avoid paying owed benefits. Knowing about at-will employment helps you understand your rights and responsibilities. Employers can change work duties, schedules, or pay without needing your approval, as long as they do not discriminate or retaliate. Many companies include disclaimers in their policies that clarify employment is at will. Still, courts may look at how the employer and employee acted to see if an implied contract exists. When reviewing your employment contract, check if it states a fixed term or requires cause for termination. If it does, then your employment isn't at will. But if it doesn't, then the default rules apply, and your job could end at any time. In summary, at-will employment is the standard in most workplaces in the United States. It provides flexibility but also means less job security. Understanding this concept helps you make informed decisions about your employment relationship and what to expect if your job ends unexpectedly.